Well, we're back. This is Brent Allan Winters, commonlawyer.com, www.commonlawyer.com, and this is a Common Lawyer Comments, and I'm here with the other elder at in church. Go to commonlawyer.com and you can read about that. And we're discussing today the grand jury, an indispensable feature of our common law tradition. The grand jury only exists in the common law tradition. Here in our country, we're a common law country. Matter of fact, in the federal courts, it's in our Constitution of the United States that we're entitled, if we're prosecuted, we're entitled to a grand jury indictment before anybody can prosecute us here in America. And Montana Dan had discussed, he is in the driver's seat to choose the questions that may be asked here. And if you don't choose the right question, you won't get to the answer you're looking for. So it's a matter of discernment. And that's the job of the elder, by the way, is to have that discernment, to be the overseer, to have the discernment, to watch out for false doctrine. And the way to do that always is to ask the right question. It's not a matter of having the right answer. It's a matter of asking the right question. So Montana Dan, I think you had a question or two. And if you can frame the thing, then we can talk about it.
Okay. In this past segments, we talked about the grand jury and that they can investigate. In a trial jury, the jurors can't ask any questions during the trial. They can after they're in deliberation. But it sounds like, from what you said, the grand jury can ask questions and maybe investigate. This might be in two questions, but it might investigate, a judge, or the motive of the prosecutor, or the motive of some public official that's bringing it. So first off question, what is the difference between, or should a trial jury be able to ask questions during a trial? Why don't you do that one first?
My answer, from my experience, should jurors in a trial be allowed to ask questions of the witnesses? And the answer is yes. The answer is yes. I haven't worked out all the details of that, but there's nothing in our common law tradition that would forbid it. But my thinking now is, Montana Dan, that the way to go about doing that's part of that is our common law tradition. How do you go about doing it in such a way that the jurors won't monopolize the time and prevent the lawyers from presenting the evidence they want to present? You allow people to talk, they're not going to stop, Dan. That's what happens a lot of times. And they get incensed. So this would have to be, as a matter of evidence, like all evidence, the gatekeeper of all evidence in a common law trial. What is allowed before the jury, the gatekeeper, is the judge. His decisions are appealable, but he is the gatekeeper in the first instance. And therefore, probably it would be a good idea, just to give it an example of how it could be done. The questions could be written on paper and passed to the judge. And then the judge could read the question and have the juror number on the paper. He would put it on there. The judge would read the question to himself and then give permission to the juror to ask the question, or the judge would read the question himself. Those are two possibilities. Now, this could get real time consuming. But it seems like it ought to be done. But we're not in a hurry here. Again, you'd have the gatekeeper of all evidence. Let's say that a juror asks a question, and the question he asked requires an answer, which is evidence. That becomes evidence, the answer, see, that is not admissible before the jury. It may be irrelevant, for instance. And that's the judge's call. Has always been that way. That's nothing new. Now, in a grand jury situation, if you'll notice, there is no judge there to say what evidence can be submitted. Why? Because the rules of evidence do not apply to grand jury proceedings. They can look at anything they want, hearsay, all the hearsay they want. In the grand jury room, the grand jury is free to ask all the questions they want without limit. And it is possible we could say, well, that's the opportunity for a juror to ask questions. But remember, the trial jury isn't privy to those questions. But that is one of the features of our common law tradition, and jurors are not, the way things are now, allowed to do that during the jury trial. Go ahead, Dan.
Yeah, I think some of the stuff you have, and then from NLA, it seems like the grand jury kind of gathers the evidence, and then they present the evidence. If there isn't a settlement, then they present the evidence to the trial jury. So the question and answer time would be in the grand jury investigation, and they cannot they investigate or ask questions of anyone they want to?
At the grand jury level, yes. The grand jury is impaneled to investigate anything they think is worthy of investigation that should be looked into. And they bring with them whatever's in their heads, whatever they know about, and they're allowed to do that.
It doesn't seem like that happens nowadays.
No,
of course, the grand jury is a kind of a secret mission. That's a bad choice of words, but they don't have to answer to anyone, but they do have the ability to gather information. But it doesn't seem like that happens now. How do we get there?
We get there through education of those that may serve on a grand jury. You see, the policy of our common law, the policy, that's a bad word. It's a law of the city word, but the way our common law has always taken jurors, whether grand jurors or trial jurors, the petit jury or the grand jury, the way we have taken them is as is. When the juror arrives in the courthouse, the jury pool sitting in the courtroom, and they're picking the jury pool, we take them as is. We don't allow people to come in and instruct the jury and try to teach them the power, for instance, of jury nullification. Teach them that they can nullify a law and ignore a statute. We don't teach them that if the judge's instructions are, in their humble opinion, unlawful, they're not bound by any oath to follow what they have come to understand as an unlawful instruction from a judge. The juror is not ultimately bound by anything. But we're not allowed to teach them that. That's our common law tradition. It's always been that way. You can teach them beforehand. You can teach them out on the streets. People passing out flyers out on the street in front of the courthouse. Oh, they'll try to stop you from doing that, but that's freedom of speech. As long as you teach the juror before the juror is in the pool and being questioned about being paneled and they're choosing the jury, that's fair game. That's what we're doing here. We're targeting people that might serve on the grand jury. We can't do this after they're in the courthouse and paneled. Again, the way our common law has impaneled jurors is called, we take him as he is. What he has in his conscience, what he has in his head, the gathered knowledge and conclusions, cut it off right there, and he's allowed only at that point, to consider the evidence presented at trial. Once he's a trial juror, nothing else is allowed. If anything else is allowed and he sees or hears any other evidence other than what is presented at trial, and somebody finds out, they can make a motion, one of the parties find out, they can make a motion to end the proceedings and start over again. And I've seen that happen. Even after the proceedings, after the verdicts are delivered of guilty, find out that there were things snuck in the jury room. Well, if you never find out, you don't do anything about it. If you do find out, you can do something about it. And you can say, make a motion to the judge, and then you can put on evidence. Well, this juror said that they had something in the jury room that wasn't presented as evidence, some testimony, some piece of evidence. That blows the whole thing. So we take the juror as he is, grand jury juror and petit juror, trial juror, and whatever is admitted into evidence before the grand jury, and remember there are no rules there. They can look at any evidence they want as long as they're in session. Or what is admitted as evidence before the jury, and remember the judge is the gatekeeper of evidence before the jury. That's appealable if he makes a mistake. That's the outlet we have in case of mistake. And usually, by the way, that's a big point of appeal. But there are rules of evidence that dictate what's allowed before the jury and what isn't in both cases. So what we're doing here is we're saying
you're talking about the trial jury, right?
Right, the trial jury. There's a gatekeeper there for evidence, but not to the grand jury level. They can look at anything they want to look at, whether you think it's relevant, whether the judge thinks it's relevant, whether the prosecutor thinks it's relevant or not. The rules of evidence don't apply. And you can't appeal on the basis, well, they broke the rules of evidence at the grand jury level. My indictment's no good. No, that won't work. That won't work. So it's important that we get to the potential grand juror and instruct him of this. He has power. He's in the driver's seat. He doesn't take orders from anybody. Except, well, they say, well, you meet here. No, he is not excluded. He's the man in the driver's seat. If he wants to tell the U.S. attorney to get out while they discuss something, they tell him, get out. You'd be nice about it. You don't want to be belligerent, but say, would you please excuse yourself? We want to discuss things without you here. Your presence has a stifling effect on what we might say. We want absolute freedom of speech inside this grand jury room. As long as you got a federal prosecutor, a federal henchman, that might prosecute me because of something I say in the grand jury, I want you out of here. I want freedom of speech, you see. Well, we don't let the prosecutor in the grand jury deliberations of the trial jury. Why would we let him into the jury room? Why? Well, by invitation only, that's why. But other than that, I'd say don't let him in. Keep him out. He's got a political agenda he's after. He was appointed to that position in many cases, yes, because he promised to prosecute somebody. I knew a local judge that wanted to throw his hat into the ring after I forget what presidential election it was, George Bush II, I think, threw his hat into the ring to be U.S. attorney. He was a state judge. They called him in for an interview. And they said, are you willing to prosecute Governor George Ryan for crimes? And he said, well, sure. He could have said, no. Well, they had a lot of people willing to do that, unfortunately. I think that's the wrong question to ask, and that's unlawful. But that's what they do. They choose them on the basis, will you go after the political opponents, for instance, of George W. Bush? Okay, we'll appoint you U.S. attorney. That's what happened. And there was another two fellows appointed in that part of the world that did go after him. U.S. attorneys did go after him, were appointed because they agreed they would. What I mean to say is the U.S. attorney and the federal prisons, it's all about politics and it's politically driven. And there isn't a whole lot of independent thought going on. It's a matter of using the U.S. attorney's office, knowing how to use the grand jury as a tool of political revenge. And it's up to you, my friend, and if they can get away with it, they will, but it's up to the grand juror to know that he is in the driver's seat, not the U.S. attorney, not the state prosecutor, if you have the grand jury in your state. Well, that's the law, my friends. I'm telling you the law. And we're not educating grand jurors. They don't educate them. We'll just teach them what the truth is. Maybe they'll follow it. Maybe they won't. Maybe they have the gumption to do that. Maybe they don't. But if they don't know, they certainly won't do it. They'll think they're working for the government. And they'll rubber stamp whatever the U.S. attorney wants. And that's against the law. That's a dereliction of duty as a grand juror. You are responsible, my friend, to know your duty as a grand juror. And if you don't know it, They say all is lost when freedom fails. Good men rot in filthy jails. That's what's going to happen without the grand jury doing its job. Back to you, Dan.
It sounds like we got our work cut out for us.
Well, sure. And it comes down to every man knowing the laws of nature and the laws of nature's God and doing the laws of nature. And if you know it, good chance you're going to do it, but you cannot do what you do not know. That's why we do these presentations. You can find us on YouTube. You can find us on Rumble. Always talking about the laws of nature, unwritten in the nature of creation, our common law tradition, and the laws of nature's God. That phrase from our Declaration of 76 was well known in that day. That signifies the Bible, the laws of nature's God. Those are our 2 volumes of our common law tradition. 2 volumes. There isn't really anything else a fellow needs to know. Just know those, know the truth, and you'll recognize the error when you see it. Don't study the error. No, study the truth, and you'll recognize the counterfeit when it pops up. Back to you, Dan.
Yeah, it's a great discussion today. We'll have to keep digging into this and educate myself and people too. So
I appreciate your questions. We depend upon Montana Dan to come up with the topics, but what that means is come up with questions. And I hope he's been able to keep a list. He has some. This is Brent Allan Winters, commonlawyer.com, www.commonlawyer.com, coming at you from the remote hinterlands of the Wabash River Valley, where the hogs, the frogs, and the dogs keep up a racket all night long. Dan and I are elders at In Church. In Church, you can learn more about In Church, the doctrinal statement, what we do when we meet. On the internet, you can watch us every Sunday, not to mention Saturdays, but Sundays. Tell you when, what link to look at, to click on to watch. You can see us and hear us. We can't see you. And those presentations are on Rumble, by the way. Support us and take the course coming up at Winters Inn, the law school, called Comparative Law, Comparing and Contrasting Our Law of the Land, our common law tradition, with the law of the city, the civil law tradition, the canon civil laws of Rome versus the law of the land, our common law. You can take that course. The comparative law text, excellence of the common law, we're going to use that. You get that with the course when you sign up. You get it in digital form. It's a 958-page book. We're not going to read the whole thing. It's not going to be but 12-week course, but we're going to hit the fundamentals with a reading assignment. commonlawyer.com. Thank you, Montana Dan.
Thank you, Brent. Also check out Brent's militia series, and I think you get into it other places too in some of the past things you've done.
The militia course was popular. That most popular course we taught. It's in the can, and you can find that at commonlawyer.com too. You can take the course. Sheriff Darleaf and myself, longtime sheriff of Berry County, Michigan, are the presenters in that course.
Okay. Thank you, folks, for coming. We'll do this again. Thank you for your time, Brent.
Thank you, Montana Dan.